Welcome back to AustLaw Simplified. Today we are looking at the sale of goods. The Goods Act 1958 governs contracts for sale of goods. It applies broadly to businesses and consumer transactions. Common law continues to apply where it is not inconsistent, and consumer guarantees under the ACL override in some contexts. Section 6 of the Goods Act defines a contract of sale as one where the seller transfers or agrees to transfer the property in goods. This definition covers both immediate sales and agreements to sell at a future time. It's important to distinguish specific from unascertained goods. For specific goods, property can pass immediately. If they perish before the contract, the agreement is void. For unascertain goods, property doesn't pass until they are identified and appropriated to the contract. The Act implies several conditions into contracts of sale. These include conditions as to title, correspondence with description, fitness for purpose, and merchantable quality. These protect buyers where goods don't meet basic expectations. Key cases illustrate how implied conditions operate. In Rowland versus Divall, the buyer recovered the price because the seller had no title. In Grant versus AKM, underwear caused dermatitis, showing lack of fitness for purpose. Ashford Shire Council shows reliance on skill and judgment of the seller. Aqua-Marine involved prawns unsuitable for Woolworths standards, breaching merchantable quality. Where goods are sold by sample, there are implied conditions that the bulk matches the sample. The buyer gets a reasonable chance to compare and there are no hidden defects. This protects buyers when they rely on a sample. The Goods Act allows implied terms to be excluded by agreement under Section 61, but the ACL prevents exclusion of consumer guarantees under Section 64. In Victorian Alps Wine Co. versus All Saints Estate, an exclusion clause was effective to remove liability for implied terms except title. Not all contracts involving goods fall under the Goods Act. If the contract is really for work and materials, it is outside the Act. In Collins Trading versus Meher, the contract was for sale of goods with incidental installation. In Aristoc versus Warham, it was held to be work and materials. So, property remained with the manufacturer. The Act provides remedies to both sides. Sellers can sue for the price, claim damages, or exercise rights over goods. Buyers may repudiate, claim damages, or seek specific performance. Risk usually passes with property, so timing of transfer is very critical. That's an overview of the sale of goods, key provisions, implied conditions, case law, and remedies. I leave you with this thought from Henry David. Success usually comes to those who are too busy to be looking for it. Thank you for watching, and I'll see you in the next lesson.